Presentation is brought to you by Synergy Business Advisors Noida, your trusted business mitra. Can you bypass the Debt Recovery Tribunal and directly knock on the High Court's door? If a bank takes action under SARFAESI, can you skip the statutory remedy and file a writ petition? In December 2025, the Delhi High Court gave a clear answer and it is a warning for borrowers. We are discussing an important judgment that clarifies the maintainability of writ petitions in banking and insolvency matters. Sanjay Krishan Sharma versus Punjab National Bank and another. This case deals with a very practical question. When special tribunals like DRT or NCLT exists, can you still approach the High Court under Article 226? Let us understand what exactly happened. Sanjeev Krishan Sharma was facing recovery proceedings initiated by Punjab National Bank. The bank had taken action under a special financial recovery law such as SARFAESI and RDB Act. Instead of pursuing remedies before the Debt Recovery Tribunal or other statutory forums, the petitioner approached the Delhi High Court directly by filing a writ petition. He sought directions and relief in respect of proceedings that were already pending before statutory tribunals. His argument was essentially the bank's action was improper or illegal, the tribunal proceedings required intervention, the High Court should exercise its writ jurisdiction. On the other hand, Punjab National Bank argued there is a complete statutory mechanism available. The petitioner must exhaust alternative remedies. High Court should not interfere when specialized tribunals exist. And that became the central legal battle. The main issue before the Delhi High Court was, is the writ petition maintainable when statutory remedies exist before DRT, NCLT or other tribunals under special laws like SARFAESI, RDB Act or IBC? The question is extremely important for borrowers, guarantors, corporate debtors, legal professionals, because many parties attempt to approach High Court to challenge recovery steps. The Delhi High Court emphasized a settled legal principle. When a statute provides a complete machinery for redressal, parties must first approach that forum. The High Court should not ordinarily entertain writ petitions in such cases. Special laws like SARFAESI and RDB Act creates specialized tribunals with defined jurisdiction. The court observed that the DRT is the appropriate forum to challenge SARFAESI actions. NCLT handles insolvency matters under the IBC. The High Court's writ jurisdiction is extraordinary, not a substitute for statutory appeal. The court reiterated that writ jurisdiction is not meant to bypass statutory remedies unless there is a clear violation of fundamental rights, there is total lack of jurisdiction, there is a gross violation of natural justice. Otherwise, the proper course is to approach the tribunal. The Delhi High Court held that a writ petition seeking directions in respect of proceedings before statutory tribunals, particularly under SARFAESI, RDB Act or IBC, may not be maintainable. This is CA and IP Praveen Agrawal thanking you for watching. I hope this presentation will be helpful for you. Please subscribe to the channel for more such business friendly videos. Thank you.